Hello everyone, my name is Kanchan Ahir. I'm from Golden Gate University, and the topic of my presentation today is whistleblowers in California. It's a part of my practicum and for the subject employment law under the guidance of Professor Cushing. So let's have a look at the agenda of my presentation. First, I'll talk about what is whistleblowing, the types of whistleblowers, what are the problems which are faced during the whistleblowing process, what is Whistleblowers Protection Act 1989, why this act was out, what is whistleblowers law in California as a state, and then we'll talk about the monetary remedies of whistleblowing. Let's begin. Okay, so what is whistleblowing? Whistleblowing is something a person who makes a disclosure of any wrongdoing, corruption, or fraud in an organization. If an employee finds out that the employer is doing something against the law, then he discloses about it, that wrongdoing or that illegal thing that his employer is actually doing in the organization, and letting the public or everyone know or disclosing about that issue is known as whistleblowing, and the person who announces it or discloses it is known as a whistleblower. So let's begin with the types of whistleblowers. There are three types of whistleblowers, such as 1. Internal whistleblowing, 2. External whistleblowing, 3. Personal whistleblowing. In an internal whistleblowing scenario, an employee reports to his immediate supervisor about the wrongdoing or illegal behavior he comes across. In external whistleblowing, it's an external case wherein that which happens mainly outside the organization. It does not affect an individual as such, but something which is external. And third, personal whistleblowing, in that it does not include an organization, but it is mainly against a particular individual. Once we know what are the types of whistleblowing, let's have a look at the problems which are faced during this process. So, there are multiple issues that are faced by the whistleblowers while disclosing the issue that they came across, out of which one is reluctance to blow the whistle. In this situation, when the employee in a team fears to blow the whistle due to important people involved, he knows that there is something wrong going on in the organization, but he is afraid to go ahead and speak out because he knows that the people involved are either at a higher level or very important to the organization. Another problem which is faced is reluctance to hear the whistle. When he reports or claims, he is being ignored by the supervisors and the managers. And the reason being, again, they might feel that this is something not so serious, or maybe also they know that there are important people involved, and that can be the reason of their ignorance. Another problem faced during this process is reluctance to see the need to blow the whistle. An employee might not be sure of blowing the whistle, whether he should talk about it or he should not talk about it. What should he do? In some situations, he does not know what to do, where to go exactly. When everyone around forces to hide the information from upper management. And even if he does, there is a lot of pressure from the upper management to that employee to not disclose the information. Now that we have looked at the problems faced during the whistleblowing process, let's have a look at what is Whistleblower Protection Act 1989. So there are a lot of cases wherein people have blown the whistle about the misconduct in an organization or a misconduct behavior, and such cases have taken forward. But those people who have blown the whistle, or we as we say whistleblowers, they have faced a lot of negative impacts on their lives. Many of the people have been fired, many of them were not treated well later, etc. etc. And the maximum case, and in the maximum cases, they are fired. So, for their protection, this law was passed in 1989. What does it say? It says that this law protects the federal government employees within the United States of America from retaliation for disclosing the illicit or unlawful activities occurring in the government organizations. So, this law is specifically for the federal government employees. As we all know that there are many common laws which are followed all across the country, but there are few laws which are specifically for the states of the country. Now let's have a look at what is the whistleblower law in California. So this law was expanded upon OSHA, that is Occupational Health and Safety Act, under section 11 subsection C. This act was expanded or extended with three new amendments added to it, namely SB 496, AB 263, SB 666. So let's talk about more in detail about these amendments. So SB 496 protects the employees who reports illegal behavior internally to person of authority, as well as employees believing their employer is violating local laws. Another one is AB 263 and SB 666. These laws basically covers the additional protection. These laws will protect the employees who have issues with unpaid wages in any form of complaint, which can be either oral or written. These laws further protect the immigrants whose employers blackmail their employees to contact the immigration authorities in retaliation of whistleblowing. Another law that was passed under this act was AB 1509, which was signed in 2016. This law says that this law protects whose family members are involved in whistleblower activities. As the name suggests, California whistleblower law, this law protects the employees of California. So, this law does not have a single law, but a lot of or multiple laws under this act which protects the employees who are facing the issues after whistleblowing. So let's begin looking at each law which falls under this act. The first law is California Labor Code LC 1102.5. Another one is Health and Safety 1278.5. The third one is Labor Code 6310, False Claim Act, and Sarbanes-Oxley Whistleblowers Law. Let's talk about each law in detail further. California Labor Code LC 1102.5. It is unlawful employment practice for an employer to terminate an employee if they refuse to violate a state or federal law or refuse to participate in a violation of a state or federal law. The second important law is Labor Code LC 6310. This is all about safe working environment. If an employee complains about unsafe working conditions, which can be oral or written, and if he is being terminated for the same, then it is unlawful on the employer's part. Now, the employee can file a complaint for retaliation to OSHA or to the employer itself. In such situations, this law protects the employee. Another very important law is Health and Safety 1278.5. This is a very important statute for people in healthcare industry. For example, doctors, nurse, etc. If any such individual complains about an unsafe condition of patient care, and if after such complaint that person is terminated, this law is violated. This complaint can be done to the employer or report to an government agency. In either situations, the employee is protected. This law creates a rebuttal presumption of retaliation. For example, after the complaint, if the employee is fired within 120 days, it is presumed that there was retaliation. This another act, which is called as False Alarm Act. This act basically talks about the frauds against the government. It's a federal and state false claim act, and this law lets everyday employees to file a legal action against their employer on behalf of the government. So they basically protect the government against the employers. So if an employee faces a situation or comes across a situation or behavior wherein he knows that his employer is doing something wrong to the government, in such cases an employee blows a whistle to protect the government, or to, let's say, to protect the government's funds or money. Such cases are called as key tam cases, which is a fancy Latin word for on behalf of. Majority of such cases are from healthcare industry, wherein the large organization submits lots of false invoices to Medicare or Medic-Aids, which are provided by the government. If an employee can bring in such case against an employer and can recover the money, then that employee gets a percentage of that money for blowing the whistle and protecting the government funds. This can be done with taxes as well. If the employer is making frauds while paying taxes, then the employee can file a case and help recover the money for government. There have been billion dollar cases wherein an individual brings a whistleblower case and made it well, which has helped government save a lot of money. Last but not the least, Sarbanes-Oxley whistleblower law, which is in short called as SOX. Let's talk about this law in detail. This law is all about corruptions that issue publicly traded securities such as stocks, bonds, and so on. If a company is issuing securities, they have to follow all sorts of disclosure laws, and those laws are all about getting the accurate information, like the financial information from the company which is issuing securities, which will help the people invest better and will not let them mislead. If you find out, or an employee finds out, that their employer is not reporting appropriate financial information, or withholds financial information, or discloses false financial information, that employee can blow the whistle and he will be protected under this law. What happens after an employee blows the whistle? What are its effects? What are the remedies to recover from those damages? Are there any? Because as we can see in the image here, after blowing the whistle, the boss is talking to the employee that you did the right thing, whistleblower, so naturally we have to fire you. Goodbye. And yes, even if we don't believe it, that's the case which is generally happening in the whistleblowing cases. So, are there any remedies which can help the employees recover? A lot of laws we discussed about has the following remedies. The first one is economic damages. If an employee was making $100,000 a year and if he blew the whistle and was terminated or fired, he can earn he cannot earn anymore. So it is his lost wages which can be taken care of by the law. Another damage is punitive damages. In the most terrible cases, if the employee can prove his termination was due to blowing the whistle about the fraud happening in the organization, then the employee is awarded punitive damages. Like the employer is punished or discouraged to behave in such manner in future. Another remedy is key time rewards. These rewards are given if an employee files a false act case. The act that we talked about, fraud against the government and the employee blowing the whistle on behalf of the government. In such cases, the employee gets paid a percentage of the recovery, which depends on the False Claim Act, which can be between 15 to 50% of the amount. Few of such cases can be very huge or gigantic, and in such cases, the plaintiffs are rewarded very well. These rewards may also include double the lost wages or attorney's fees. And with this, I complete the presentation and I hope you liked the video. Thank you so much for watching this. And to get more details about whistleblowers or whistleblowers in California, you can check for the references below. Thank you.